Good morning. Fantastic judgment. The law scholars, young lawyers, read practitioners must understand this judgment. And number one, first, whether the High Court has got mandatory power, mandamus power, directing the state government to notify the rules framed by the Chief Justice. And threatening dealing, I may say that threatening dealing of the judges court while dealing with contempt proceedings. Seeing bailable warrant, taking custody, so many things had happened in Uttar Pradesh, and that was referred to Supreme Court. Supreme Court has categorically held that High Court does not have power to direct state government to notify the rules proposed by Chief Justice regarding post-trial benefit for former judges of High Court. Thereafter, the Supreme Court has given direction stating that standard operating procedures already framed must be followed while dealing with these things. Therefore, there were near about multi number of standard procedures, how to deal contempt proceedings. They say a term was used at paragraph 43 of the judgment. This court in state of Uttar Pradesh was Manoj Kumar frowned upon the frequent summoning of government officials at the drop of a hat. This is what a practice has developed in certain high courts to call officers at the drop of a hat and to exert direct and indirect pressure. The line of separation of powers between judiciary and the executive is sought to be crossed by summoning the officers and a way pressurizing them to pass an order as per whims and fancies of the court. So they have at paragraph 45, a standard operating procedures on personal appearance of government officials has been categorized. Kindly go through that. That will definitely help you. Then what had happened? What actually happened for this pronouncement of judgment AR 2024 Supreme Court 475. AR 2024 Supreme Court 475. State of Uttar Pradesh versus Association of Retired Supreme Court and High Court Judges at Allahabad and others. See, they want some domestic help to former Chief Justice and former judges of High Court. So for that they have framed some rules, and they want that rules to be notified. Since that was not notified, they filed a contempt application. At the contempt application, they seem to have filed a legal objection stating that there is to recall the order. So that counter itself was considered as a contemptuous attempt. Therefore, the Supreme Court has rightly held. So I remember several instances when the proceedings were going on. House orderly brought a innerwear, ladies' innerwear, showed to the court as well as all advocates that he was supposed to wash this bloody the innerwear containing blood. This had happened several times. Sometimes what had happened, some electricity default resulted judges' residence non-functioning of ACs. So they immediately suo motu contempt initiated. The engineering authority was made to sit inside the campus till evening till that restoration is. These all are somewhat more than that also had happened, and somehow the advocates representing state being brave, honest, and intelligent. Sometimes they get over this year. This judgment is also by a painful effort of the government advocates appearing for the Uttar Pradesh government. So this judgment you have to read it carefully. So this may be referred for answering the questions about the separation of powers of judiciary, as well as how to initiate contempt proceedings, how to deal with the contempt proceedings, when personal appearance may be imposed, whether the preliminary inquiry was there. So many things have been discussed, which will be very helpful. I hope you understand. Best wishes.